those who are on the line already, we're going to give it just about a minute, and then we will go ahead and get started with our webinar. Kim and Denise, you can see the screen, correct?
Yes.
Great. Okay, it looks like people are joining, so I will give it maybe one more minute. And I know we have a lot of material, so then we'll go ahead and dive in. All right, I want to welcome everyone to today's training on the basics of special needs trusts. We are very happy to have Denise Fike with us to present the training. I am going to share just a little bit of information about MVLS and why we're having this training, and then we will go ahead and dive into our main topic. First off, just kind of sharing that if you are interested in learning more about other things that we're doing at MVLS, like other trainings that we do or events we have going on, volunteer opportunities, you can follow us on social media or on our website. And I just wanted to show everyone as well, if you are interested in volunteering with us and you're not a current volunteer, this is what the front page of our website looks like. You would click on volunteer where the arrow is pointing, and you can see what's called our pro bono portal, where we list the various types of cases that we have available that are in need of attorneys. So this is what it looks like. You can sort by subject area, and then you can click on learn more to express your possible interest in taking a case. So I am always happy to answer questions for new volunteers, so please feel free to reach out to me directly after the webinar if you would like to ask questions about that. I just wanted to talk a bit about why we invited Denise to give this training today. So many of our MVLS clients, and I'm sure for those of you on the line, your clients as well, have disabilities or have family members who have disabilities. I know we get questions about this topic all the time. For MVLS, approximately 30% of our clients self-report as having a disability of some kind. And we offer estate planning services at MVLS. That is one of the core areas that we offer services in. And one of the reasons we do that is to help families transfer intergenerational wealth, particularly families of color. We know that there is a significant gap in Black families, particularly being able to transfer their house, which is often our client's main asset, from one generation to the next. So that is something that is a core of the services that we provide at MVLS. But many of those families that come in for estate planning services do ask us about how to plan for a special needs family member. And so that is, some of what we're going to cover in today's presentation. What are special needs trusts? What are the basic things you need to know and be looking out for? So with that, I just want to thank everyone for joining us, for being an MVLS volunteer or supporter. And I'm going to turn the presentation over to my colleague, Kim, who will introduce our presenter.
Thank you, Margaret. And we are pleased to welcome Denise Fike. She is the current, since 2011, CEO and Executive Director of First Maryland Disability Trust, although she's been there since 2009. It's a nonprofit organization serving individuals with disabilities, all ages, all disabilities, with over 1,000 clients and over 65 million in assets. As a corporate trustee, Denise Pike's firm provides low-cost trust management for people with disabilities to protect and use trust assets while they preserve their clients' eligibility for public and private benefits. Just a brief background on her: after she attended Villa Julie College, which is now Stevenson, in paralegal studies, she served as a paralegal for 27 years, working with personal injury clients, guardianships, estates, and general litigation before moving to Susquehanna Trust and Investment as the trust officer, where she served in a variety of accounts, including those with special needs. So without further ado, I'll turn it over to Denise Pike.
Thank you, Kim, Margaret, and I appreciate the opportunity to talk a little bit about First Maryland and also about the special needs and special needs community. So the areas that we're going to focus on today, and feel free to ask any questions. We're going to talk a little bit about benefits. We're definitely going to talk about special needs trusts, how it relates to guardianship, litigation, and ABLE accounts, because I'm sure most of you have heard about those as well. We're going to talk about public benefits. And so if you want to flip to the benefits means tested versus entitlement screen. Number 5. Awesome. Okay, so
Are we, is
one
this the
more.
right slide, Denise, or keep going?
One more, number
One more.
5.
Sorry,
Thanks. Nope, that's fine.
apologize. I can't see the numbers. There we go.
Okay, so public benefits. We're going to talk a little bit about how they intersect with housing and healthcare, food, SNAP program, etc., both means tested and entitlement benefits. Next slide. So means tested versus, you hear people talk about, well, Social Security's entitlement benefit. Not totally. Means tested benefits cannot have more than $2,000 to $2,500 in your name. Would be Social Security supplemental income, or SSI, and Medicaid. Medicaid is the $2,500. Waiver programs, long-term care, definitely means tested. Food stamps and subsidized housing. HUD is a whole conversation unto itself. Subsidized housing doesn't necessarily mean Section 8. It can mean, there are grant programs that will help a disabled person subsidize their rent by paying part of it, not just getting Section 8 housing. So again, that's a whole nother topic, and not my bailiwick, thankfully. I know enough of that to be dangerous. Entitlement benefits. So SSI means tested. You have not paid in for this. Entitlement benefits, you have worked and you are entitled, and I kind of use that in air quotes, to use those benefits after qualifying. Now, I'm not talking about just retirement benefits. That's a different level, but Social Security disability income, if you've got enough quarters and you are disabled, theoretically, there's an intent to return to work. But you can collect your disability or SSDI. Disabled adult benefits kick in when there is additionally a disabled adult child of someone who has worked and that person has retired. So mom or dad have worked all their life. They have an adult disabled child and dad retires. Adult disabled child can go from SSI to SSDI, taking part of dad's, a percentage of dad's retirement, or retirement benefit is disability income. And then, of course, there's Medicare. We all know that when you turn 65, you will automatically become enrolled in Medicare, or you're automatically qualified. But if you are disabled, from the time your disability is determined, there is, I believe, an 18-month waiting period. So theoretically, you're still on Medicaid, or you may have a supplemental policy or different policy. There's an 18-month waiting period to get onto Medicare. So Next slide, 1993, the Omnibus Reconciliation Act, which also gave the same benefits in 2000 to foster care children, gave exceptions for special needs trusts for those individuals who needed to preserve assets, liquid assets primarily. And these are the two regulations that we're going to talk about today, dealing with the special needs trusts. And you will see under the Social Security Act, the 42 USC 1396, we do refer to the differences of D4As and D4Cs. Next slide. So Maryland, other way. Maryland, back in the early, like 2015, 2016, with a lot of lobbying, decided that special needs trusts were a good thing. And we were able to get them to add into the code this section 14.5-1002B, which does say that it is the state's policy to encourage the use of special needs trusts. The whole reason to use a special needs trust, and we're talking first party money versus third party money, and I'll talk about that in a minute, is to encourage people with disabilities, to allow them to save, conserve assets, to enhance their quality of life, and not supplant what benefits might be available to them through whether it's DDA, whether it is waiver programs, whether it is SSI, Medicaid, etc. Okay, so types of trusts. Next slides. Back way. Yeah, that one. Thanks, Margaret. So first party trust, third party trust, you're going to follow the money trail. The first party trust means it is the beneficiary with the disability's own money. However it came to them, medical malpractice settlement, personal injury, somebody left them money and did not put it into a special needs trust already. It's not designated. There's two types under the 1396, D4A and a D4C. D4A is a standalone trust. It means realistically, your client goes to an attorney, they draft a special needs or supplemental needs trust. It is then passed, it is passed through Social Security for approval. And they don't really give you an approval. They just send back and say it complies. And then you pass it through the state of Maryland on behalf of Medicaid. They stamp it with approved on it, and your trust is good to go. It's only that person's money in the pot. So whatever you're investing, whatever you're using, it's only that person's money, as opposed to a D4C, which is a pooled asset trust. And those are where there's a master trust agreement and a joinder, and we'll talk about that in a minute. So then you have Medicare set-asides. Those are used primarily in some personal injury cases, workers' comp cases, they're really prevalent. It's where you're setting aside money to pay for future expenses, future medical bills with Medicare, not Medicaid, Medicare. Those, again, are a whole different level of trust, but you can use them in conjunction with a special needs trust for your client. And then there's revocable trusts. You know, mom and dad want to put their money into the pot. They want it all to be in a trust, becomes irrevocable upon the last to die. And so there's a different level. A lot of those will contain special needs language, especially for remainderment. C2B3 and C2B4 trusts, we're not going to talk about them too much today. Those are special needs trusts. So think of it as mom and dad together. Mom has special needs and she has created a trust. And if her money goes into a D4A, if she were to pass, so say she needs long-term care, her money goes into D4A before she's age 65. And for some reason, and there's a spousal spend down, because you're going to wind up with that. If there's a married couple, and she's disabled, but they have a disabled child. And one of the things we'll talk about is the payback requirement. First party special needs trusts are paybacks to the state for Medicaid for that person's lifetime, not just when the trust was installed or instituted, but through the person's lifetime. So mom and dad are married. Mom goes into long-term care, needs Medicaid because there's not enough assets. Dad, this community spouse, has his share, and they have a disabled child. Mom is able to have a C2B3 or 4 exception, which instead of paying Medicaid, will leave the money to a special needs trust for the disabled child. Again, those are, and at that point, there's a payback after the disabled child passes to the state of Maryland or whatever states they've lived in, and whoever has a Medicaid lien proportionately. It's a little more convoluted than that, but you got the gist. Third party trusts, everybody else's money. Money does not belong to the individual with the disabilities at the outset. Now, the trust is set up for their benefit, but the money didn't belong to them. So you're looking at testamentary trusts, estate planning. It could be a Maryland discretionary trust, a revocable trust, which is now irrevocable because, you know, the first party grantors have passed away and they've left money in that trust for someone with special needs. Or there's also a third party pool. Some states allow them. Actually, most states allow them. And First Maryland actually has a third party pooled account. Again, master trust agreement and a joinder. And if I talk too fast, somebody needs to just let me know. Okay, so we're going to do the first party trust slide. Next slide. First party trust, D4A. Again, first party money belongs to the individual. Those who can establish it are the individual themselves if they're competent. Now, let me just preface this slide and the next one with competency does not mean they can advocate for themselves and say, I want to wear blue versus red today. There is a self-advocacy that a lot of the organizations look towards and say, well, the client is competent, they can make their own decisions. There is a huge difference between understanding documentation to be signed and the effects of what it does versus the ability to decide what color shirt you want to wear. It's sort of a bone of contention with me, but just understand that if you're bringing a client to us, we're going to push for some sort of an evaluation, some documentation of a disability and their competency to sign a document. So money comes again, personal injury settlement, medical malpractice, etc. The D4A, here's a difference in A and a C, and it's in your documentation. D4A has to be funded before age 65, cannot have any deposits after age 65. And that can be a problem because a lot of the clients that we see aren't disabled until after age 60 or 65, or they're cutting it really close because maybe they've had a stroke. They're not, the physical disability a lot of times kicks in, or the mental health because of dementia kicks in. They don't have the long-term disability that someone with developmental disability or mental health might have. So understand that after age 65, D4A is out, D4C is in. Beneficiary has to obviously be considered disabled, and that is the inability to perform job functions for a period of 18 months or more. That's the general definition. Medicaid on a D4A must be reimbursed if the client has received Medicaid anytime throughout their lifetime, Medicaid comes first. If there's any funds left over the Medicaid lien, then they can be left to remaindermen, family, estate, whomever. But the state gets their cut and or states in a proportionate share to what they've spent on the client. Can be established by the beneficiary, the parent, the grandparent, legal guardian, or the court. And the legal guardian is the guardian of property. Guardian of person cannot establish and fund a special needs trust. Okay, D4C. Here's the difference. D4A, anyone can be the trustee. The D4C is different because it must be managed, set up and owned or operated, if you will. Owned is really the wrong term because you're looking at a nonprofit. It has to be a nonprofit agency. Funds, again, trust can be created by the same group of people, can be funded before or after age 65. Now, again, the difference in a D4A and a D4C is the documentation. The D4A, you're going to have an attorney draw up the document. You're going to pass it through. A D4C or a pooled asset trust, you have a master trust agreement, which is established by the nonprofit, and you have a joinder agreement. The joinder agreement is what brings the client into the trust. Both the master document and the joinder have already been approved or noticed that we've complied with Social Security rules and have the stamp of approval from the state of Maryland on behalf of Medicaid. It's a little trickier in that while you don't technically need an attorney to have a D4C set up, we suggest to everyone that they consult an attorney first, not leaving the attorneys out of the loop, because parents have issues. There's a lot of other problems. You want to make sure that they've got trusted legal counsel, and it would be a conflict of interest for our counsel to advise them, well, this is what you need, and to, do that particular piece of it. So we have a lot of attorneys that we work with, and we refer out. So the next difference is, because this is a nonprofit, the federal law allows the nonprofit trust to retain the funds in the account. And in fact, the law says that to the extent the trust does not retain the funds, the state is repaid. So First Maryland gives everybody options. You can, if the account is smaller than the Medicaid lien, you can leave all of it or none of it to First Maryland. If it is left to First Maryland, it goes into our charitable pot, and we can talk about that in a few minutes. The bottom line on that scenario where the money in the account is less than the lien is no one else is going to get it but the state or the nonprofit. So then if the money in the account is more than the state lien, then you still have, clients still have an option to leave it all to First Maryland or repay the state and name the remainder beneficiaries. And that's really where we, unless we already know that the lien is going to be less, we steer everybody towards pay the state, name a remainder. And again, you're looking at before or after age 65. And so it can be established and continuing funds deposited after the age of 65. Okay, next slide. Third-party trusts can be standalone or pooled. Again, third-party pool has a master trust agreement. Your grantor or settlor chooses the remainderman. Typical estate planning tool. Revocable or irrevocable to start. And then once the grantor dies, it's obviously irrevocable. Next slide. So break it down a little bit. This is just for your information. It goes back to, who establishes whose distributions after death. Remember that third-party pool or third-party trust, there is no payback because the money did not belong to the individual with the disability. It belongs to everybody else. It is not mom's responsibility to repay Medicaid for services that their child, adult or child itself, received. Grantor's wishes on the death remainderment, it's whoever mom and dad, if they're the ones establishing that trust, want a name. Grandparents, whomever. So follow the money trail if you have a question. All right, next one. Guardianship of property. So the estate and trust article now allows the guardian of property of a disabled person or minor to transfer money into the special needs trust. A guardian can transfer it to a D4A, and that trust is subject to court jurisdiction. If they transfer it to a D4C, it is no longer subject to court jurisdiction unless for some reason it needs to be. But because the AG's office has approved the trust and we are a corporate trustee, we don't have that requirement to be subject to the court jurisdiction on that one. Understanding that if you are doing a guardianship, when the funds come from a guardianship into a trust, they are no longer guardianship funds. They no longer belong to the individual. They are set aside in a trust for the individual's benefit, but they're not accountable as a resource on the guardianship reports. They're also no longer accountable for income or for SSA, SSI benefit. Once the funds are put into the trust, they're not accountable resource for benefits, for Medicaid, for Social Security, etc. Now, depending on how the money is spent, it can become accountable resource, but that particular disbursement, and we'll talk about that in a minute. Relationship to guardian, for the pooled trust, you want to think about, it's not an alter ego. The pooled trust is not part of the guardianship. The guardian has no control over the funds that are in the trust. In order to be a properly run, executed special needs trust, the trustee must have sole and absolute discretion on how the funds are spent. Cannot be ordered by the court unless under court jurisdiction, cannot be ordered or demanded by the beneficiary or by anyone else. Total and absolute discretion. Guardians need to understand what their client's benefits are. Are they means tested? Are they entitlement? Are they in a nursing home? Are they in a group house? All of those things interact with the trust when you're setting them up. Those benefits will determine how the trust can be spent. For instance, SSI is for food and shelter, while the POMS, the operating manual for Social Security, says that it is for sole benefit and you cannot use trust funds for SSI, because SSI is food and shelter. The POM says you can't spend money from the trust for food and rent without it causing a reduction, 1/3 reduction, of the SSI benefit. Does not mean that we can't do it. It just means it will cause a reduction. So when a guardian brings a client to us and brings money into the trust, they need to be able to tell us what that client's benefits are. And we ask that whether it's a guardian or not, but the guardian needs to know what their client's benefits are or what they could apply for if they don't know.
We do have a question, Denise.
Go for it.
Okay. If a person has a will and is expecting a personal injury award, what happens if they pass away before they receive the award? How can they avoid probate and shelter their award from payback? This might be above and beyond the scope of what we are addressing here, but I don't know if you have thoughts on any of that.
So the person has a will, they're expecting a personal injury award.
Mhm.
There's really not going to be a way to shelter that. Because that money belongs to, assuming it belongs to the same person. So Joe has a will, he's been injured, he's expecting to receive at some point a personal injury award. It's going to get payable to his estate. There isn't any way to avoid the probate. You're not going to be able to assign it or anything like that. At least not that I know of, unless somebody comes up with a better way to do things.
All right, thank you.
And that part is, again, it is going to be subject to the payback, because the state of Maryland has a lien against everyone for whom they've paid Medicaid benefits. Even if there is no trust, they're going to place a lien against that estate if that award goes in. Now, the other thing that you can do is negotiate that lien, so that even if, say, he essentially, the only thing in his estate is going to be that award, and he's getting $100,000 net, comes into his estate, but the Medicaid lien is $150,000 and there's no other assets to pay it. You can negotiate that. The state of Maryland will negotiate it. Now, will they negotiate it down to nothing? No, but you might be able to cut that lien in half and preserve some of those funds from the estate. It just depends on the timing. It depends on who you talk to, and it depends realistically on the size of the lien. So unfortunately, you're not going to be able to shelter it. Okay. So guardianship of property, you can read all of that down. What I will say to you, if you are a guardian of property and you are putting money into the special needs trust, do not wait until you have spent it all down, but what you anticipate your fee to be. And while that sounds counterintuitive to what those who only serve as guardians do, because that's how they make their money, it is not in your client's best interest to spend it all down, because especially if they're in a nursing home and they need additional services that aren't provided, maybe one-on-one care, then there's no money. If you've spent everything down and all you're putting into the special needs trust is enough money to preserve your fee. And if those are times we would be having a conversation. Foster care. So back in 2018, 19, might be before that, the state of Maryland determined that they were not conserving enough funds, SSI money, for those children who were in foster care and who were able to qualify for SSI benefit. And so they set a structure for conserving funds. So First Maryland is one of the pooled trusts that was approved by the state. There are several of us to be able to hold those conserved funds for the foster care children so that they have funds for when they age out of the system. And there is a slide a little bit further back on what that schedule is. So, all right, let's flip. We can kind of flip through this back to the litigation slide. One back. It wasn't as far back as I thought. Okay, so right there, the SINA one. Yep. So there's your schedule for what has to be conserved percentage wise, because not every child is going to receive the same percentage of benefits. Benefits will change depending upon the child, where they're living, what their medical expenses are, those types of things, waiver programs. So not everyone is going to get the full SSI payment, but they've given you a range of percent of dollars that you need to conserve if you're a foster parent or a case manager, because realistically, the case managers are the ones, the social workers, the ones that bring it over to the trust. Okay, litigation slide, please, next one. We did talk very briefly about the MSAs. Those structured settlements as well can be put into the trust. Medicare and Medicaid have rules that govern both the trusts and the money that is set aside for the MSA, how it's able to be spent, the receipt requirement, all of those things. And they require a lot more scrutiny and reporting than what a D4A or D4C might be. Plus, you have to deal with CMS when they look at the receipts and you figure out, you know, is this something that is really related to the injury that caused the Medicare set aside to be set up in the first place? Is it part of that injury as future medicals, or is it something totally different? Those are questions that we leave to the people who handle the MSAs. Structured settlements and special needs trusts. The next two slides actually talk about that. So, next slide. There we go. Structured settlements, personal injury, medical malpractice. We get a lot of these. I want to say that, and more, just toss it out there. While we handle both pooled and non-pooled trusts, when there is a settlement that is larger than $250,000, which is kind of an arbitrary threshold for the best dollar amount to start investing individually, as opposed to pooling those funds, we look at whether a pooled trust or a standalone is best. But you start with the age, because obviously over 65, it's a no-brainer. It goes into the pool. But we look to work with the litigation attorneys, and then hopefully they will have engaged a special needs and or estate planning attorney, to someone that works with disabilities, to talk about a special needs trust. And that's where we work with both attorneys to say, okay, this is really good or this isn't. Structured settlements are good in some things. They help to expand the life of the funds that are being essentially given or awarded to the client. They can be put into either a D4A and funneled in, or a D4C. And it is possible that if those funds are not done correctly, along with the non-structured piece, that benefits could be temporarily terminated. We try not to let that happen. The structures work well for younger families or younger persons with disabilities. And what we look for when we set a trust up that has a settlement of any sort, personal injury, medical malpractice, even family law, you know, a divorce decree or whatever, if money is to go into the trust, we want it in a court order. That solves a lot of problems down the pike, but especially with a settlement, we want to make sure that you may not have filed suit you're settling beforehand, but we want that settlement agreement to have been court blessed because we don't want an issue with our client and the structure down the road. As an example of working with the clients and the attorneys, we have a workers' comp case where there is a disabled father passed away, there's a disabled child. The settlement is in excess of $1 million. The structure people obviously want to put it all in a structured settlement and funnel little bits into the trust. However, there's a housing need. And so the housing need for the child preempts the structure. What money does the child need? How old is he? What's his disability? What's his medical need? Medical equipment need in this one is a big thing. So you're looking at wheelchairs, you're looking at Hoyer lifts, you're looking at other things that will potentially affect where this person can live. And so in order to have funds set aside for this child's living and housing, we went back to the structured settlement people and said, this is not a good idea. And the broker was on board after we talked about it. This is why it's not good. These are the dollars we're going to need for housing. This is what it's going to take to upkeep that house over the next 3 to 5 years. These are the potential medicals for this child. And so instead of a structured settlement, that money, with the exception of the workers' comp money that will pay through a structured settlement to the child because he's entitled to those funds from dad's behalf, everything's going to come into the guardianship and then into the trust. So structured settlements can be good. They can be a steady stream of income into the trust when the cash is not needed immediately. We have a client who is in her late 70s, had a stroke in her 60s, actually at 65. She is, she's got a structured settlement that funnels money into her trust every month that help pays her medical needs. She got a lump sum and a structure. The structure is what's keeping her medical needs up to date. It's built up a little bit, but you know, it's a good way to make those monies last longer. Okay, family law. Special needs trusts can be a good place for someone with a disability who is part of a divorce or child support to place those funds into the special needs trust and conserve them. So alimony, husband and wife are divorcing and wife is disabled and is entitled to alimony and no children. She's entitled to alimony. Alimony because she's in a nursing home. So she has to meet, and she needs long-term care Medicaid. She has to meet that spend down requirement, and she has to meet the threshold of not over $2,000 at any point in liquid assets. Their divorce settlement money, whatever she was entitled to receive, comes into the special needs trust. The alimony is directed into the special needs trust because it then belongs to her. Yeah, it might be husband's money paying her, but it's her money. And so it doesn't go into a third party trust. It goes into a first party trust because it's for her benefit. And so then the trustee is able to assist with additional expenses that might not be covered in long-term care Medicaid. Or she's on a waiver program. She has subsidized housing. She has in-home care and supports. The trust is able to then help pay for the things that are not paid by Medicaid and the waiver programs. Property settlements can come in. realistically, you don't want, especially if it's somebody over 65, you don't want to put a house into a pooled trust, but we can hold it in a standalone, but that you have to be really careful about. And a lot of times, the houses, if it's over somebody over 65 and that person, the disabled person, is staying there and they're on waiver benefits, there are ways to handle the house. And because it's an exempt resource from the $2,000 limit, it can stay in her name. So again, I'm hitting pieces of things that you might hear. And if any of this sticks with you and you've got questions, feel free to call me or email me. Email me is best. And we can talk about how the special needs trust might work with the scenario that you're dealing with. These are things that we've all dealt with before. And so we're able to help or guide in whatever manner it might be. So ABLE accounts, you're going to hear about these. You're going to hear about these in conjunction with special needs trusts. They can work in tandem. They can work separately. The Achieving a Better Life Experience Act went into effect in 2014, and in Maryland in 2016. You must be deemed to be disabled under age 26. There is, and has been for several years, a push to make that age 42 or even higher. And the thing about the ABLE accounts, and when you have a child with disability that you're working with, you want to make sure you get as much medical and psychological documentation as possible. Not just IEPs from school, but the medical information. Because if you're looking to have somebody open an ABLE account, you're going to need that. But the reality is you're going to need that for any benefits that they're going to get through the rest of their lifetime. And a lot of people don't save that kind of information, which is really a shame, especially not so much now. Families now know to save it, or they're reminded and told to save it. But families from years ago, the 50s, the 60s, the 70s, didn't save it because there was a stigma to being disabled. And we don't want our child labeled, so we didn't have them tested. We don't know what it is. And all of a sudden, when they go to do different programs, there's no backup information. You know, schools don't keep stuff that long. Doctors don't keep things that long. It doesn't stay in perpetuity anywhere except with the family. So make sure you're pushing families to keep as much documentation as possible.
Denise,
So
sorry, one more question, going back to something you had been talking about prior to ABLE account, I think.
Okay.
Can a spouse create a revocable special needs trust for the other spouse?
So special needs trusts are always irrevocable.
Okay.
They must be irrevocable. The adult spouse, the non-disabled spouse can create in their estate planning, if that's the way, they can create an irrevocable third-party special needs trust now while they're alive, or they can create a special needs trust in their estate document, in their will, for their spouse, and it does not become a countable resource. That's assuming that the spouse is not already in long-term care. They can still do it even after that, but by then they've already done a spousal spend down. So, but yes, you can. But a special needs trust is always irrevocable. Okay. So the ABLE Act serves as a savings plan. Now, the thing to know about a special needs trust and an ABLE Act is they're governed by different entities. The ABLE Act is governed by the IRS. So while there is a list of disbursements that are what they call qualified disbursements, you're not going to know if the IRS has approved those until you file your tax returns. The special needs trusts are governed by federal and state law and predominantly by the Social Security POMS and the Maryland Comar Act. And they're reviewed periodically. The IRS doesn't review your ABLE account until you filed your tax returns and you're looking to having made the qualified distributions. Think of it as a 529B or 529A rather, sorry. They are one account per person, so none of this is pooled. There are only certain agencies within the state that are allowed to operate them or be the trustee or manager of those monies. The thing with this is there is a limit to what can be placed into the ABLE account each year. This year it's $17,000 if you're a person with disability from all sources. Now, these are payback accounts to the extent that the state, however, has said, if you have a Maryland ABLE, we are not going to make it a payback to the state of Maryland for Medicaid. We're going to kind of disregard that, and you can pass it to whomever you want. I still tell families, do not mix money in the ABLE accounts. Do not mix third party and first party money, because while the state has said they're not clawback accounts for now, they could change their mind. Nothing is ever set in stone. And so I tell people just the person with disabilities money should go in this account. Other states will tell you differently. And attorneys will tell you differently. But grandmom doesn't want to put $15,000 a year into this account for this client, for their child, only to have potential to be clawed to the state when it could be left elsewhere. So safety, just don't mix the money. However, the client can, or anyone realistically, this year it's $17,000 a year is the maximum deposit, except if the disabled person is working. Out of the funds that they are allowed to make, they can deposit an additional $13,590 into the ABLE account in this year. Last year it was less, next year will probably be more. Contributions to the ABLE are tax deductible, and this ABLE account does not count as a resource, which is exactly why they were founded or put through Congress, does not act as a resource for Medicaid and Social Security benefits. So an ABLE account can work in conjunction with the Special Needs Trust. The person with a disability can manage their own ABLE account. You see a lot of parents that manage them because the disabled person really can't manage money. Representative payees can also establish, an ABLE account. I will caution you that what we have seen over the last couple years since that went into effect, that the representative payees are, no, you cannot open two ABLE accounts, one per person. What we've seen from agencies that are rep payees is they've opened the ABLE account on behalf of their client and they've made themselves the remainderman. Conflict of interest, clear conflict of interest. So if you're dealing with someone who has an ABLE account, double check who opened it, who manages it, who the remaindermen are. You've got in your materials the dollar amounts for this year. There's also the Maryland ABLE website at the end, so that you can check out what the requirements are, how to apply, that kind of thing. A little bit about, and this is not in your materials, a little bit about how First Maryland operates. So we have trust officers or trust administrators in our organization that when a special needs trust comes into us, we ask for a lot of documentation. we need the medical background. We need a care plan if they're in a nursing home. That gives us a starting point of where the client is at that point, what the disability is, what the plan of care might be, what kind of medications they're on. As much information about the individual as possible. All the benefit letters for whatever public benefits they're receiving, SSI, SSDI, SNAP, Medicare or Medicaid, all of the insurance information, because that is how we determine how we're able to make distributions from that person's trust without jeopardizing their benefits. Because the whole goal is to not supplant their benefit money and things that they're able to receive through their benefits, but to supplement it. Case in point, we have a client who has who is wheelchair disabled, wheelchair bound, has a manual wheelchair and an electric one. At one point in time, needed both replaced. Medicare and Medicaid only pay for one, and you have to take your pick. So because we had funds in the client's trust or for the client here, we got together with that person's advocate and said, okay, he has Medicaid. Medicaid will pay for a wheelchair. Let's have Medicaid pay the more expensive wheelchair, the electric one, but Medicaid doesn't pay the upgrades. So we'll pay the upgrades and we'll pay for the manual chair, because between the two, they're less than what Medicaid was going to be spending on the electric one. And it worked out because we were then able to get the client what they needed, work around the benefits, and still conserve some money for the client in their account so that we could use it for other things that they needed. And later on, that client needed additional wheelchair repairs that weren't going to be paid for. So we were able to do that. So we look for that information to know how to best spend the money on behalf of the client. When a disbursement request comes into us, if it's in on Monday, it's usually out by Thursday. Unless you're talking about vacations or cars, houses, we go for court orders. And where somebody is available by email all the time and by phone pretty much throughout the week. You know, even into the evenings, if there's an emergency, we can deal with that. First Maryland also has expanded where we do serve as guardian of property. We can also serve as a bill paying organization. Maybe somebody just, you know, doesn't know how to write a check or they've never handled the bills. We can help them do that. We also serve as representative payee for clients. Most of those clients already have a trust, but they can't manage their money. There's no other family. And so we're able to serve as rep payee for them. And we also have started as financial power of attorney. And that's a little trickier, but it does work. So open for questions. That's my whole spiel. Here's where you can find me. Email is best, but always welcome to call, leave me a message, and I will call you as soon as possible.
So Denise, I just want to thank you again so much for being with us today and for giving this presentation. I am going to invite people to put their questions in the chat. If anyone has any additional questions, I'm just going to run through really quickly. MVLS has some other recent trainings on a wide variety of topics that you can see here on the screen. Everything from consumer law to our human trafficking prevention program to our tax program. So please feel free to, these are recorded, just like this training that you attended today was recorded and will be available on our website. Again, a link for people to volunteer if they're not a volunteer yet. But Kim, do you have any questions? I have not seen any additional questions come in on the chat yet.
No, I don't have any additional questions at this time. So thank you again. This was a wonderful presentation, and certainly the presentation pamphlet to keep.
Only other question I saw is, are they going to get a copy of the PowerPoint? We will put it on MVLS's website, so that's how we share out both the video of the presentation as well as the PowerPoint. Yes. All right, well, thank you again. We really do appreciate your time, Denise.
You're welcome.
And,
Thank you.
Yeah, have a great rest of the afternoon, everyone.
Yes,
Thank you.
All right. Okay, see you later, Kim. Thanks again for bringing us all together. You're muted.
Thank you for doing that. I didn't know how much you wanted me to take care of logistics, but this is wonderful.
Yeah, that was great.
This is wonderful for our department.
Oh, yeah, I know. I was like, I should have put some more information at the beginning about how it was relevant to our guardianship department. So sorry.
Yes,